Next, Clause 57, Surviving Rights. In PEM 2018, I found Clause 25.4, Rights and Duties of Employer and Contractor, while in CIDB 2000, I found Clause 44.3, Effects of Determination of Contractors' Employment. For comparison, PEM 2018 is the most similar to PWD203A, Clause 57, in spirit and legal effect. Both preserve mutual rights and duties beyond termination. CIDB 2000, while related, offer a more limited scope, only preserving the employer's right and omitting explicit reference to the contractor's surviving entitlement. We can relate this to a Malaysian case, which is Muda Jaya Corporation Berhad versus Leighton Contractor Sendirian Berhad 2015. In this case, the dispute revolved around the survival of right after termination in the context of a construction contract in Malaysia. Muda Jaya Corporation Berhad, the subcontractor, had entered into a subcontract construction project. However, the subcontract was terminated by the main contractor, Leighton Contractor. Following the termination, Muda Jaya Corporation made a claim for payment for the work completed prior to the termination. The central issue in this case was whether Muda Jaya Corporation was still entitled to claim payment and other remedies after the termination of the subcontract. Essentially, the court had to decide whether the termination of the contract has extinguished the rights of the subcontractor to pursue claims for work completed before termination took place. The High Court ruled that termination of the contract does not extinguish rights or claim that had already occurred until the date of termination. The court emphasized that the subcontractor's right to claim for payment for work done prior to the termination were preserved. The court further held the accrued rights are enforceable even after termination unless the contract was specifically excludes them. Next is Clause 58, Effect of Force Majeure. In PEM 2018, I found Clause 23.8, Relevant Events, while in CIDB 2000, I found Clause 24.1, Extension of Time. For comparison, in PEM 2018 and CIDB 2000, force majeure allow the contractor to claim for extension of time, but not to terminate the contract. In contrast, PWD203A Clause 58 goes further by allowing either party to terminate the contract if force majeure make the work impossible or impracticable to continue. We can relate this to a Malaysian case, which is Chung Mayeng versus Puncak Dana Development Sdn Bhd. In this case, Chung Mayeng versus Puncak Dana Development Sdn Bhd 2002, the dispute arose when the developer failed to deliver vacant possession of a property within the stipulated time under the sale and purchase agreement. The developer attempted to justify the delay by invoking the force majeure clause in the contract, claiming that the delay was due to factors beyond their control, such as difficulties in securing approval for water and electricity supply, and issues related to the sewerage treatment plant. However, the court found that the developers' delay were not truly the result of uncontrollable external events. Next, Clause 59, Side Agent and Assistant. In PEM 2018, I found Clause 8, Side Agent, while in CIDB 2000, I found Clause 13.2, Contractor's Representative. For comparison, all three clauses require the contractor to appoint a full-time site representative on site. CIDB 2000 focuses on giving the representative full authority, while PEM 2018 and PWD203A focus more on needing approval and allowing removal by the architect or SO. We can relate this to a Malaysian case, which is Outlaw Development Sdn Bhd versus Saw Yew Leong, High Court Malaya, Penang 2002. In the case of Outlaw Development Sdn Bhd versus Saw Yew Leong Leong, which was heard in the High Court of Malaya. The dispute involved the role and responsibility of a professional engaged in supervising aspect of construction project. Accor Development Senang Berhad, the plaintiff and a property developer had appointed Xiao Leong as the consultant mechanical and electrical engineer for a housing development in Penang. As a part of his engagement, the consultant was tasked with preparing engineering design, obtaining the necessary statutory approval, and supervising installation work and ensuring that the system, such as the lift installation, were completed according to the contract and relevant standard. However, issues arose when the developer alleged that the consultant had failed in his supervisory role. In particular, the consultant was said to have neglected his duty to monitor the lift installation and failed to properly coordinate with the authorities, resulting in delays and complications. Next, Clause 60, nominated subcontractor and or nominated supplier. In PAM 2018, I found Clause 27, nominated subcontractor, while in CIDB 2000, I found Clause C1, nominated subcontractor and or nominated supplier. For comparison, PAM 2018 and CIDB 2000 focus on private sector flexibility, with CIDB 2000 integrating supplier into the nomination process, while PWD203A is highly regulated for government procurement with strict compliance measure. PAM 2018 keep the main contractor responsible. CIDB 2000 balance obligation between contractor and nominated parties, and PWD 203A ensure strict oversight under public sector rules. We can relate this to a Malaysian case, which is Bauer Malaysia Senang Berhad versus 100 Vision Construction Senang Berhad and Anna 2020. In this case, Bauer Malaysia Senang Berhad was appointed as a nominated subcontractor by the main contractor 100 Vision Construction Senang Berhad for the substructure work in a high-end service suite project known as Tribeca. The main contractor was in turn appointed by employer Bhakti Dynamic Senang Berhad. During the course of the project, damage was allegedly caused to an adjacent building. The owner of the building initiated legal action against the employer, the main contractor, and the nominated subcontractor, alleging negligence. And a key issue in this case was whether the employer could sue the nominated subcontractor for negligence, given that there was no direct contractual relationship between them. The court examined the contractual arrangement and emphasized the principle of privity of contract. It held that generally a nominated subcontractor does not have a direct contractual relationship with the employer, and therefore the employer cannot sue the nominated subcontractor for breach of the contract.